Hi friends, today we are discussing on companies mediation and conciliation rules 2016. These rules are framed by central government, and central government gets the powers conferred under section 442 read with section 469 of the Companies Act 2013. Let us discuss these rules in detail uh, in this session. What this section 442 of Companies Act 2013 tells. So the title of section 442 is Mediation and Conciliation Panel. Clause 1 talk about central government shall maintain a panel of experts to be called as mediation and conciliation panel consisting of such a number of experts having such qualification as may be prescribed. So this particular list of mediation and conciliation panel has to be maintained by the central government. And what purpose? So for mediation between the parties during the pendency of any proceedings before central government or tribunal or appellate tribunal under this Companies Act 2013. So throughout these rules, the pending cases before the central government or a tribunal or appellate tribunal, those cases can be referred for mediation or conciliation. Clause 2 talks about any of the parties to the proceedings may at any time during the proceedings before, at any stage of the proceedings which was pending before maybe central government or tribunal or appellate tribunal, the parties may apply to the concerned respective authorities like central government or tribunal or appellate tribunal, as the case may be, in such form along with such fees as may be prescribed. There is a format and fixed fees is there. So along with the fees in the prescribed format, they have to submit for referring the matter pertaining to such proceedings to the mediation and conciliation panel, and the central government or tribunal or appellate tribunal, as the case may be, shall appoint one or more experts from the panel referred to in subsection 1. So it means central government shall maintain the panel of experts to be called as a mediation and conciliation panel, and the concerned parties, the case pending before the central government or tribunal or appellate tribunal, may apply in a prescribed format with a prescribed fees, and then the concerned central government or tribunal or appellate tribunal shall appoint one or more experts from the panel referred in subsection 1. The central government or tribunal or appellate tribunal, these are the three words repeatedly comes in these rules. This before which any proceeding is pending may suo motu refer any matter. So the clause 2 talks about on application, clause 3 talks about even by suo motu also the matter can be referred to the mediation and conciliation wherever the central government or tribunal or appellate tribunal deems fit. And the fee and other terms and conditions of experts of the mediation and conciliation panel shall be such as may be prescribed, so that everything will be decided before it was referred to mediation and conciliation. The mediation and conciliation panel shall follow such procedure as may be prescribed, and dispose of the matter referred to it within 3 months from the date of reference. And any party aggrieved by the recommendation of the mediation and conciliation panel may file objections to the central government or the tribunal or appellate tribunal, as the case may be. So the against the decision of the mediation and conciliation decision, the aggrieved party can file a objections before the concerned maybe central authority or tribunal or appellate tribunal, as the case may be. So that is the section under which these rules are framed. And let us now discuss the rules. So rule 3 discuss about panel of mediators or conciliators. So at the beginning we will discuss who has a power to prepare panel of the experts, all the procedural aspects that is discussed in the beginning the rules. So rule 3 talks about regional director shall prepare a panel of experts willing and eligible to be appointed as a mediator or conciliators in the respective regions, and such a panel shall be placed on the website of the Ministry of Corporate Affairs or on any other websites as the case may be notified by the central government. So it is the duty of the regional director. He has to prepare the panel of experts willing and eligible to be appointed as mediators and conciliators, and the list has to be put up on the website. The regional director may invite application from persons interested in getting empaneled as mediator or conciliator and possessing the requisite qualifications specified in Rule 4. Later rules prescribes what is the eligibility, who are qualified, who are not qualified. All the details are given in later rules. So the regional director may invite applications from persons interested in getting empaneled as a mediator or conciliator. Clause 3 talks about a person who intends to get empaneled as mediator or conciliator and possesses the requisite qualifications shall apply to the regional director in form MDC number 1. So here regional director may invite the application, and when the invitation is given, the interested person who wants to be empaneled as a mediator or conciliator and who is having a requisite qualification shall apply to the regional director in a prescribed format, that is form MDC number 1. This is a format which contains the minimum information. It has to be submitted by the interested person who wants to become a mediator or conciliator. So all the details in this format he has to fill it and submit to the regional director. Then clause 4 talk about the application received in that particular format. If rejected by the regional director, then regional director shall record the reasons in writing why it was rejected. Clause 5 talk about regional director shall invite applications from persons interested in getting empaneled as a mediator or conciliator every year during the month of February and update the panel, which shall be effective from 1st April every year. So this procedure of invitation, receiving application, scrutinizing and finalizing the list is a regular process every year regional director has to do. Then Qualifications for empanelment. Are who are qualified? So persons belongs to any of these categories are eligible, qualified to become a mediator and conciliator. So who are those people? So given the list starts with uh, any person has been a judge of the Supreme Court of India, judge of High Court, judge of District and Session Court, member or registrar or of a tribunal constituted at the national level under any law for timing in force, and officer in the Indian Corporate Law Service or Indian Legal Service with 15 years of experience, qualified legal practitioner for not less than 10 years, professional for at least 15 years of continuous practice as a chartered accountant or cost accountant or company secretary, a member or president of any state consumer forum, now it is a commission, expert in mediation or conciliation who has successfully undergone training in mediation or conciliation. These are the persons eligible to apply to become a mediator or conciliator under these rules. Next rule is talk about disqualifications who are not eligible to apply for mediator or conciliator under these rules. Who are those people? What are the criteria for disqualification? A person shall be disqualified for being empaneled as a mediator or conciliator if he is an undischarged insolvent or has applied to be adjudicated as an insolvent and his application is pending, one who has been convicted for an offense which in the opinion of the central government involves moral turpitude, a person removed or dismissed from the service of the government or corporation owned or controlled by the government, a person who has been punished in any disciplinary proceedings by the appropriate disciplinary authority, then any person in the opinion of central government such a financial or other interest in the subject matter of the dispute or in related to any of the parties as is likely to affect prejudicially the discharge by him of his functions as a mediator or conciliator. So these are the people who falls under these categories will not become a the apply for under these rules. Then rule 6 talk about application for appointment of mediator or conciliator and his appointment. Clause 1 talk about parties concerned may agree on the name of the sole mediator or conciliator for mediation or conciliation between them where there are two or more sets of parties and are unable to agree on a sole mediator or conciliator, then central government or tribunal or appellate tribunal may ask each party to nominate the mediator or conciliator, or the central government tribunal appellate tribunal may appoint the mediator or conciliator as may be deemed necessary for mediation or conciliation between the parties. The application to the central government or tribunal or appellate tribunal as the case may be for referring the matter pertaining to the any proceedings pending before it for mediation or conciliation shall be in form number 2 and shall be accompanied with a fee of 1000 rupees. So any party, disputing parties, and a case is pending before the central government or tribunal or appellate tribunal, any of the party can file an application in prescribed format, form number 2, and along with that prescribed form, he has to pay the fees of 1000 rupees along with the application. On receipt of this particular application, then the concerned authority shall appoint one or more experts from the panel, from the list. The central government or tribunal or appellate tribunal, as the case may be, before which any proceeding is pending, may suo motu refer the matter pertaining to such proceedings to such number of experts from the mediation. So everywhere, whosoever, whichever party wants, they can apply. If second one, nobody has applied, but the concerned authority felt that this matter can be settled through mediation or conciliation, in that situation, by suo motu, they themselves referred that matter to the mediation and conciliation. Ultimately, if it fit in the interest of the parties. So this is the format in which they have to give an application to the concerned authority. Rule 7 talk about deletion from the panel. Whenever regional director may, by recording the reasons in writing and giving an opportunity to the concerned mediator or conciliator, after hearing that concerned person, the regional director may remove from the panel. So there should be a reasons, and those reasons has to be disclosed, and opportunity should be given to that particular person. After hearing that, the regional director has a power to remove any person from the panel. Then rule 8 talks about withdrawing name from panel. In this particular rule, any person who intends to withdraw his name from the list, then he has to write a letter, give an application to the regional director indicating the reason why he is withdrawing, and then regional director will take a decision on that application within 15 days of receipt of that application. Rule 9 talk about the duty of mediator or conciliator to disclose certain facts. So in majority of the chapters or rules or regulations under different legislation, majority of the things, majority of the duties, responsibilities are same under different legislation. But whichever, wherever or under which legislation the case is referred, that act, that rules are applicable. Here we are talking about the under the Companies Act, and we have to restrict ourselves rules and rules under this particular act. So this particular duty of mediator or conciliator to disclose certain facts. So what it says, that it is the duty of the mediator or conciliator to disclose to the central government or tribunal or appellate tribunal, as the case may be, about any circumstances which may give rise to a reasonable doubt as to his independence or impartiality in carrying out his function. So he himself, when a case is referred to the mediator, and mediator has to disclose, because the central government or tribunal or appellate tribunal, as the case may be, they may not know the mediator or conciliator connection with the the referred dispute and referred disputing parties. So that's why the mediator has to disclose all those information to the concerned authority. Every mediator or conciliator shall, from the time being his appointment, throughout the continuance of the mediation or conciliation proceedings, without any delay, disclose to the parties about existence of any circumstances referred to in sub rule. So even if the case is referred to the mediator, and mediator before starting proceedings, he has to disclose to the parties if any information, any connection with the dispute or the parties, he has to disclose before starting that particular proceedings. Then rule 10, withdrawal of appointment. Central government or tribunal or appellate tribunal, as the case may be, upon receiving any disclosure furnished by the mediator or conciliator under rule 9, or after receiving any other information from party or other person in any proceedings which is pending, and on being satisfied that such a disclosure or information has raised a reasonable doubt as to the independence or impartiality of the such mediator or conciliator, may withdraw his appointment and in his place appoint any other mediator or conciliator in that proceedings. Ultimately, the mediation or conciliation is a voluntary process, and parties' trust is very, very important, and the system also entertain or encourage that trust build up in the proceedings. So if any information comes to the concerned authority and doubt about the independence and impartiality of the mediator, then it is better that person name has to be withdrawn, and in his place other mediator has to be referred, provided that mediator or conciliator may offer to withdraw himself. So the tribunal or appellate tribunal or central government may inform to the concerned mediator this is the situation, then the concerned mediator or conciliator may offer to withdraw himself from the proceedings. So in that situation, the another mediator or conciliator is appointed in his place. Rule 11 talk about procedure for disposal of matters. Procedure. So this is very important. What procedure should be followed to dispose of the case through mediation and conciliation? So for the purpose of mediation and conciliation, mediator or conciliator shall follow following procedures. Which are those procedures? Let us discuss one by one. He shall fix in consultation with the parties the dates and the time of each mediation and conciliation session where all parties have to be present. He means here mediator or conciliator. He shall hold the mediation or conciliation at the place decided by the central government or tribunal or the appellate tribunal, or such other place where the parties and the mediator or conciliator jointly agree. So in those places the proceedings can be taken place. Then he shall conduct joint or separate meetings with the parties depending on the type of parties, behavior of the parties, type of a case. Mediator or conciliator has to decide joint session is proper or separate meetings are proper to settle the matter amicably. So he has to decide accordingly. He has to do that particular meetings. Each party shall 10 days before a session provide to the mediator or conciliator a brief memorandum setting forth the issue which need to be resolved and his position in respect of those issues and all information reasonably required for the mediator or conciliator to understand the issue, and a copy of such memorandum shall also be given to the opposite party or parties. So once the mediator or conciliator is appointed, date is fixed, then each party shall 10 days before the session, before that particular session, both parties who have to provide all the information, memorandum setting forth the issues which need to be resolved and parties' position in respect of those issues. All the concerned reasonable information should be provided to mediator or conciliator, so that before starting the session, mediator or conciliator understood the facts of the case, issues, position of the parties. Then it is easy for the mediator or conciliator to handle the dispute, handle the parties more effectively. Provided that in suitable or appropriate cases, the above mentioned period may be reduced at the discretion of the mediator or conciliator. Then each party shall furnish to the mediator or conciliator such other information as may be required by him in connection with the issues to be resolved. So if mediator asks some other documents or information which is not provided as of now, so those information he can get it from the parties. Where there is more than one mediator or conciliator, may first concur with the party that agreed to nominate him, or thereafter interact with the other mediator or conciliator with a view to resolve the dispute. So that is also can be done. Rule 12 talk about mediator or conciliator not bound by the Indian Evidence Act 1872 or the Code of Civil Procedure Code 1908. So already we know that this is one type of alternative dispute resolutions, and intention is for the speedy disposal. If you apply CPC or Evidence Act, then it takes more time. So that's why under Rule 12 it is clearly mentioned, instructed, mediator or conciliator should not bound by the Indian Evidence Act or the Civil Procedure Code while disposing of the matter, but shall be guided by the principles of fairness, natural justice, having regard to the rights and obligation of the parties, usages of trade, if any, and the circumstances of the dispute. So mediator has to follow principles of fairness, natural justice, and respect to the rights and obligation of the parties, usages of trade. All those things should be considered while dealing with the mediation or conciliation proceedings. Rule 13 talk about representation of parties. Always in alternative dispute methods, party in person is encouraged, but if a party wants to represent personally, welcome, or if party wants to represent through an authorized attorney at the sessions or meetings notified by the mediator or conciliator. provided that the parties may be represented by the authorized person or counsel with the permission of the mediator. So every time whichever party wants to bring somebody other than the party, then they have to inform to the mediator or conciliator with their uh, consent. They have to bring and represent the case. Provided further that the party not residing in India may, with the permission of the mediator or conciliator, be represented by his or her authorized representative at the sessions or meetings. Rule 14 talks about consequences of non-attendance of parties at sessions or meetings on due dates. Parties file an application and concerned authority appointed a mediator, and mediator fixed the date and time for the proceedings. So when meeting is fixed and parties are not coming, then what next? So that is rule 14. If a party fails to attend a session or meeting fixed by the mediator or conciliator deliberately or willfully for 2 consecutive times, the mediation or conciliation shall be deemed to have failed, and mediator or conciliator shall report the matter to the central government or tribunal or appellate tribunal as the case may be. So mediator or conciliator has to try his level best to convince the parties to come for meeting, but deliberately or willfully continuously 2 meetings they were absent, then the mediator or conciliator has to submit a report to the concerned authority, so that the concerned authority should know what is the status, because there is no meaning in continuation with the proceedings when parties are deliberately willfully absent. Then rule 15 talks about administrative assistance. Mediator or conciliator alone, he cannot do all the work. So with the consent of the parties, he may arrange for administrative assistance by suitable institution or a person. Rule 16 talk about offer of settlement by parties. Any party to the proceeding may without prejudice offer a settlement to the other party at any stage of the proceedings with a notice to the mediator or conciliator. Similarly, any party to the proceedings may make with prejudice offer to the other party at any stage of the proceedings with the notice of to the mediator or conciliator. Rule 17, role of mediator or conciliator. What is their role? So here, always mediator or conciliator shall attempt to facilitate voluntary resolution. After receiving the information from both the parties, identifying issues, he always try meeting the parties jointly or severally to identify issues and try to reduce misunderstandings, clarifying priorities. Through this, he can neutralize their bias, neutralize whatever they took a stand, and then he can bring both the parties exploring areas of compromise and generating options in an attempt to resolve the dispute, emphasizing that it is the responsibility of the parties to take decision which affect them, and he shall not impose any terms of settlement on the parties. So, mediator or conciliator here facilitating the parties to settle the matter. He cannot, he shall not impose any terms of settlement on the parties because it's a voluntary process. Provided that on the consent of both the parties, the mediator or conciliator may impose such terms and conditions on the parties for early settlement of the disputes as he may deem fit. So that is possible. Rule 18 talk about parties alone responsible for taking decision. Earlier rule also talk about that. So ultimately parties, after understanding the situation, after understanding the issues and solutions, future consequences, on all these facts, ultimately parties alone are responsible for taking decision. So this particular rule talk about the party shall be made to understand that mediator or conciliator facilitates in arriving a decision to resolve the dispute, and he shall not and cannot impose any settlement, nor the mediator or conciliator give any assurance that the mediation or conciliation shall result in a settlement, and the mediator or conciliator shall not impose any decision on the parties. So this has to be clearly followed in the proceedings. Rule 19 talk about time limit for completion of mediation or conciliation. Time limit. So one of the very important characteristics of alternative dispute resolution is quickly dispose of the case. So here also rule 19 talk about that. The process for any mediation or conciliation under these rules shall be completed within 3 months from the date of appointment of expert or experts from the panel. On the expiry of 3 months from the date of appointment of expert from the panel, the mediation or conciliation process shall stand terminated, means it comes to an end after expiry of 3 months. In case if it is not completed within 3 months and the tribunal or appellate tribunal or central government may, on the application of a mediator or conciliator or any of the parties to the proceedings, if they request extension of the period, then they extend the period for another not exceeding 3 months. Not exceeding 3 months. So it means maximum without extension within 3 months it has to be disposed of, maximum 3 months. With the approval extension another 3 months, 3 plus 3, maximum 6 months case has to be disposed of, not more than 6 months. Rule 20 talks about parties to act in good faith. When disputing parties comes before the or approaches mediation or conciliation, they should involve themselves with a good faith. Then only the result will come out. So this rule 20 talks about all the parties shall commit to participate in the proceedings in good faith with the intention to settle the dispute. Intention to settle the dispute. Rule 21 talk about confidentiality, disclosure, and inadmissibility of information. So this is also very important rule. When mediator receives factual information concerning the dispute from any party, he shall disclose the substance of that information to the other party. Provided if party gives the information and also instruct the mediator or conciliator subject to specific conditions that the information may be kept confidential, the mediator or conciliator shall not disclose that information to the other party. Especially this happens when the separate meetings happen, separate sessions happens with the parties by the mediator or conciliator. Then party may disclose that these are the facts or truth of the case, and you can disclose this much part to the other party, and other part keep it confidential, don't share with the other party. Then the mediator or conciliator has to maintain that confidentiality, because this is completely on trust based outcome. So parties trust should be maintained by the mediator or conciliator. Clause 2 talk about on receipt or perusal or preparation of records, reports and other documents by the mediator or conciliator while serving in that capacity shall be confidential, and the mediator or conciliator shall not be compelled to divulge information regarding those documents nor as to what transpired during the mediation or conciliation before the referred concerned authority, like maybe central government or tribunal or appellate tribunal or any other authority or any person or group of persons. So the mediator or conciliator shall be confidential, and he or she should not disclose all those informations before anybody. Further clauses, clause 3 talk about party shall maintain confidentiality. Even see, earlier clauses talk about mediator or conciliator has to maintain confidentiality. Now party shall maintain confidentiality whatever discussed during the proceedings, and shall not rely on or introduce the said information in other proceedings as to view expressed by the parties in the course of mediation, documents obtained during the mediation, proposals made or views expressed by the mediator, admission made by the party. There shall be no audio or video recording of the mediation. No statement of parties or the witness shall be recorded by the mediator or conciliator. So all those things has to be maintained. Rule 22 talks about privacy, and in these mediation and conciliation sessions or meetings shall be conducted in privacy, and where the persons as mentioned above rule 13 shall be entitled to represent parties, but other persons may attend only with the permission of the parties and with the consent of the mediator or conciliator. Rule 23 talks about protection of action taken in good faith. When mediator or conciliator takes a decision means he acts with the consent of the parties, because it's a voluntary process. In these proceedings, whatever the mediator or conciliator does, in that situation no mediator or conciliator shall be held liable for anything which is done or omitted to be done by him in good faith during the mediation or conciliation proceedings for civil or criminal action, nor shall be summoned by any party to the suit or proceedings to appear before the central government or tribunal or appellate tribunal, as the case may be, to testify regarding information received by him or action taken by him, or in respect of drafts or records prepared by him or shown to him during the mediation or conciliation proceedings. So that is the immunity mediator or conciliator is getting. So he should not be questioned or called, summoned in any of the courts asking any of the information during that mediation or conciliation process. Rule 24 talk about communication between mediator or conciliator and the central government or tribunal or appellate tribunal. Whatever communication happened among these people or institution, so what is the rule or what is the principles they have to follow? In order to preserve the confidence of parties, the central government tribunal or appellate tribunal, as the case may be, and the neutrality of the mediator or conciliator, there shall be no communication between the mediator or conciliator and the central government or tribunal. So once the case is referred to mediator or conciliator, whatever happens in the proceedings, then there should not be communication between the mediator or conciliator with the referred authority, maybe central government or tribunal or appellate tribunal. The mediator has to keep confidentiality. Only at the end he can share operative portion of the settlement success or failure report. Here, provided that if any communication between the mediator or conciliator and the central government or tribunal is necessary, it shall be in writing, or copies of the same shall be given to parties or authorized representative. Everything is transparent, no secret. So if any information is given to the central government or tribunal, then same copy, written copy, should be shared with the disputing parties also. Provided further that communication between the mediator and the authorities shall be limited to communication by the mediator or conciliator. It should be limited to communication and not other things. About the failure of the party to attend, what that communication connected, related to, about the failure of the party to attend, about the consent of the parties, about his assessment that the case is not suited for settlement through mediation or conciliation, about settlement of dispute between the parties. That should be the communication content. Then Rule 25 talks about settlement agreement. After doing all the procedural aspect, following the all ethical rules, and keeping the trust of the parties, then at the end settlement agreement comes into picture. Clause 1 talk about where an agreement is reached between the parties in regard to all the issues or some of the issues in the proceedings. The same shall be reduced in writing and signed by the parties, and if any counsel has represented the parties, the counselor or mediator may also obtain the signature of such counsel on the settlement agreement. So mediator or conciliator facilitating the parties, removed the misunderstandings, try to settle the matter, and parties voluntarily agreed to settle the matter as per their terms and conditions, and that is reduced in writing, which is agreed by both the parties, and that written document should be signed by the concerned parties, and if any counsel has represented his signature, and at the end conciliator or mediator, he has to sign on that particular settlement agreement, and then the agreement of the parties so signed shall be submitted to the mediator or conciliator, who shall, with the covering letter signed by him, forward the same to the central government or tribunal or appellate tribunal. And clause 3 talk about where no agreement is reached at between the parties before the time limit specified, that is 3 months or additional 3 months, no settlement is possible, then mediator or conciliator shall report the same to the central government or tribunal or appellate tribunal in writing. Everything should be in writing. If all the issues are settled, it's complete settlement agreement. If some issues settled, some issues not settled, to the extent of issues settled, to that extent settlement agreement completes, and those issues not settled, those issues will continue in court. Rule 26 talk about fixing date for recording settlement and passing order. So here central government or tribunal or appellate tribunal shall fix the date of hearing normally within 14 days from the date of receipt of report of the mediator or conciliator under Rule 25. And on such date of hearing, the central government or tribunal, as the case may be, is satisfied that the parties have settled their dispute, it shall pass an order in accordance with the terms thereof. If the settlement disposes of only certain issues arising of the proceedings on the basis of which any order is passed, as stated above, the central government or tribunal shall proceed further to decide the remaining issues. So here earlier rules talk about both parties agreed for settlement and put up their terms and conditions voluntarily, signed that agreement, and also the concerned mediator or conciliator signed. Then that mediator will submit to the concerned authority, maybe central government or tribunal. Then the central government or tribunal shall fix the date of hearing within 14 days from the date of receipt of the report of the mediator, and accordingly it shall pass an order in accordance with the terms as they agreed. If some issues are not solved, then those issues shall proceed further to decide the in the court. Rule 27, expenses of the mediation and conciliation. This is also very important. Whatever expenses happens during this particular proceedings, who has to pay, how much has to pay, that is discussed here. At the time of referring the matter to the mediation or conciliation, the central government or the tribunal or the appellate tribunal may fix the fee of the mediator or conciliator, and a consolidated sum may be fixed rather than for each session or meeting. So before referring the matter to the mediation, the fees is fixed for the mediator, and that has to be consolidated sum rather than each session fees. The expenses of the mediation or conciliation, including the fees of the mediator or conciliator, costs of the administrative assistance, and other ancillary expenses concerned, shall be borne equally by the various contesting parties. So, who has to pay the fees? That fee is not only the mediator fees, it includes mediator fee plus cost of administrative assistance plus other ancillary expenses. Altogether, whatever total amount comes, so that has to be borne equally by the various contesting parties. So, equal sharing in the expenses. Each party shall bear the cost for production of a witness on his side. So, whomsoever brings, so they have to bear their expenditure. Clause 4 talk about mediator or conciliator may, before the commencement of the mediation, direct the parties to deposit equal share of the probable cost of the mediation, including the fees to be paid to the mediator or conciliator. So that has to be deposited. And if any party do not pay the amount, then the central government or tribunal shall, on the application of the mediator or conciliator or any party, issue appropriate directions to the concerned party who has not paid. Clause 6 talk about mediation shall commence only on the deposit of amount. In case amount is not paid, before such commencement, the mediation or conciliation shall be deemed to have been terminated. Deemed to have terminated. If amount is not deposited, then the mediation or conciliation will not continue. It will terminate after giving reasonable directions, opportunity. Even then they have not paid, then mediation or conciliation shall be deemed to be terminated, closed. Rule 28 talks about ethics to be followed by mediator or conciliator. Ethics is very, very important, and ethics is the one which develops mediation and conciliation encouragement in the society. Once the society trusts these procedures and trust ethical rules are followed, then majority of the disputing parties prefer mediation and conciliation rather than approaching the hearing the matter in courts. The mediator or conciliator shall follow and observe the rules strictly and with due diligence, not carry on any activity or conduct which shall reasonably be considered as a conduct unbecoming of a mediator or conciliator, uphold the integrity and fairness of the mediation, ensure that parties involved in mediation are fairly informed, adequately understanding of the procedural aspects of process, satisfy himself or herself that he or she is qualified to undertake and complete the assignment in professional manner, disclose any interest or relationship likely to affect impartially or which might seek an appearance of partiality or bias. Further, avoid while communicating with the parties, any impropriety or appearance of im- impropriety thing, so that has to be taken care. Be faithful to the relationship of trust and confidentiality. Conduct all proceedings relating to the resolution of dispute in accordance with the relevant applicable law. Recognize that mediation or conciliation is based on the principles of self-determination of by the parties, and that the mediation or conciliation process lies upon the ability of parties to reach a voluntary undisclosed agreement. Maintain the reasonable expectations of the parties as to confidentiality and refrain from promise or guarantee of results. Provided that if any party finds conduct of mediator or conciliator violative of ethics laid down in this rule, the party may immediately bring it to the notice of regional director. So usually once the regional director appoints a person in the panel and central government or tribunal refer the dispute to the concerned mediator or conciliator, and whenever the parties comes to know that the concerned mediator or conciliator not following the ethical rules, then immediately the parties have to inform to the regional director, so that regional director will give reasonable opportunity to the concerned mediator, and later the regional director can remove that particular mediator and appoint another mediator in his place. Rule 29 talk about resort to arbitral or judicial proceedings. When dispute is referred for mediation or conciliation, during that particular time the party shall not initiate for any arbitral or judicial proceedings in respect of the matter that is subject matter of the mediation or conciliation. It cannot be referred, except that the party may initiate arbitral or judicial proceedings where, in his opinion, such proceedings are necessary for protecting his rights. So, in but majority of the cases, it is not allowed. Rule 30 talks about matters not to be referred to the mediation or conciliation. These are the matters which are before the central government or tribunal or appellate tribunal. These following cases, types of cases, are not referred for mediation and conciliation. Which are those matters which cannot be referred? Matters relating to proceedings in respect of inspection or investigation under Chapter 14 of the Act, or the matters which relate to defaults or offences for which applications for compounding have been made by one or more parties. Cases involving serious or specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion, etc. Cases involving prosecution for criminal or non-compoundable offences. Cases which involves public interest or interest of numerous persons who are not parties before the central government or tribunal or appellate tribunal, as the case may be. So these are the type of matter cases or matters not to be referred to mediation or conciliation. So this is about the mediation and conciliation under the rules framed under the Companies Act. So I hope you understood mediation and conciliation under the Companies Act, which is very, very important and very useful. The matters can be settled through mediation and conciliation, which is confidential, and companies may protect their reputation from in these cases. It will not be disclosed outside. Thank you. Thank you very much.